allowed under their own law. Okay, now Tony Abbott came to a meeting in town here, and it's pretty rare that you get politicians to come to a public meeting, so I went along and I asked him for some documents. I said to him, I want you to send me documents. I do not want you to answer the question because I know you'll speak for 10 minutes and not answer the question. So I'll deal with two of the documents I asked for. And one was the document that overrides the UN Charter and allows British law, the Constitution, to be used in Australia, given that Britain is a foreign power. Okay, well the High Court has ruled Britain's a foreign power, and this is still unquestionably British law. And I mean, it makes sense, doesn't it? You wouldn't have German, French or Italian or Russian law or whatever as the main law in Australia. So if Britain is a foreign power, then it just doesn't make sense to have the law of a foreign power the superior law in Australia. And I also asked for the document that overrides section 44 of the Constitution, allowing MPs to swear allegiance to a foreign power and sit in Parliament. You remember S44 was the one they ruled Heather Hill out on because she had allegiance, or she was a subject or a citizen of a foreign power. Now, the answer to the first request came back. If I understand the first question correctly, the answer is that no document is relevant in this context. Since the Statute of Westminster 1931 and the Australia Acts 1986, there is no document that allows British law to be used in Australia. Australia is now fully independent. So there's no document that allows British law, and this is unarguably British law, and as I said later you'll see where even the High Court in England state that. So that answer has literally ruled out the Constitution. And the other document I asked for, no document overrides S44. The Stykes versus Cleary case 1992 clearly shows that the Constitution takes precedence in this matter. So S44 must prevail. And S44 reads, any person who is under acknowledgement of allegiance is the key word, obedience or adherence to a foreign power, or is a subject or a citizen, or entitled to the rights or privileges of a subject or a citizen of a foreign power, shall be incapable of being chosen or sitting as a senator or a member of the House of Representatives. So section 44 says if you have allegiance to a foreign power, you are incapable of being chosen or sitting as a senator or a member of the House of Representatives. That's quite clear. And section 42 says, every senator and every member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance again in the form set out in the schedule to this Constitution. So the oath they have to swear is in the schedule to this Constitution, which I showed you earlier, and it reads, I, their name, do swear that I will be faithful and bear true allegiance again to Her Majesty Queen Victoria, her heirs and successors according to law, so help me God. And there's a note at the bottom, the name of the King or Queen of the United Kingdom of Great Britain and Ireland for the time being is to be substituted from time to time. So now it would read, of course, Queen Elizabeth II, her heirs and successors according to law. But it is clearly to the United Kingdom of Great Britain and Ireland. The High Court has ruled the United Kingdom to be a foreign power. So under section 44, the one they ruled Heather Hill out on, clearly all members of Parliament have sworn allegiance, as the key word, to a foreign power. So says the High Court. So how can they sit in the Parliament? Section 44 rules them out. So while we're on that sort of subject, there's qualifications of members in section 34. And this is to do with Heather Hill again, and it says, he must be a subject of the Queen, either natural born or for at least 5 years naturalised under a law of the United Kingdom or of a colony which becomes a state, or of the Commonwealth or of a state. So it's telling you there that you must be a subject of the Queen to qualify for election. And why wouldn't it? this is a constitution for a colony. Under this constitution we are all subjects of the Queen. That is of course before the 1948 Citizenship Act was passed. However, it would appear that Heather Hill was probably the only one qualified to sit in the Senate if she has to be a subject of the Queen. So it would seem that the High Court has ruled directly against Section 34 of the Constitution. Now this is the Royal Styles and Titles Act 1973. There were two of these passed, one in 53 and one in 73. This is the latest one, so this is the one we'll deal with. And the title given to the Queen was Elizabeth II, by the grace of God, Queen of Australia, her other realms and territories, head of the Commonwealth. So that is the title given to her in 1973. And there's no problem with them giving her that title, none at all. They could give me the title King of Australia tomorrow if they wanted to. But what they cannot do is bestow the authority upon such a person to appoint governors and governor-generals. There is simply no provision for that in the Constitution. That right remains solely with the Queen of the United Kingdom, and we're told now that she no longer has it. Okay, now here is the latest Governor of Queensland, Quinton Bryce, and this is her commission, and she's appointed by Elizabeth II, by the grace of God, Queen of Australia, and her other realms and territories, head of the Commonwealth. Exactly that title created in 1973. And on the second and last page of this commission, it says, given at our Court of St James this 4th day of March 2003 in the 52nd year of our reign. So you would take 51 years from 2003, that brings you back to 1952, and I guess with the month of the year it could even possibly be 1953. So that clearly is the Queen of the United Kingdom. Clearly. It certainly cannot possibly be the title at the front here given to the Queen of Australia in 1973, who has issued this commission. So I believe the government is living on a lie with this Queen of Australia business, and I think that is a mistake they have made, that clearly that's the Queen of England at the Court of St James, and you do your mathematics, and clearly on the front page it's the title created in 1973. And here's the one for Philip Michael Jeffrey, our present Governor-General. Again, it's Elizabeth II, by the grace of God, Queen of Australia, and her other realms and territories, head of the Commonwealth. Appointed and given his commission by the Queen of Australia. And this is letters patent, issued in 1984, and again by the Queen of Australia, exactly the title given in 1973. So I believe that after this date, 1984, this date of this letters patent, no Governor-General could possibly claim to have valid legal authority, because the Queen of Australia simply doesn't have authority to issue letters patent. And